So for the question 1 is Tekun Niaga Berhad, an investing company based in Johor Bahru, had appointed Sarah as its sole auditor. In discharging one of her main duties as an auditor, Sarah completed her audit on the company financial statement for the current financial year. Her auditing report will be presented in the upcoming annual general meeting. However, there are some issues arose where Sarah had negligently prepared her audit without adhering the right ledger framework. Unknown to her, Salem, an investor who had suffered heavily loss as a result of his reliance on Sarah's audit account, wanted to initiate a ledger proceeding against her. So for this case, the issue is whether Salem can sue the Sarah. So for the law is auditor powers and duties under the common law. For A, duty to third party. Under the common law, also an auditor may own a duty of care and skill to person other than the company itself, even though there is no contact between them, such as the investor and Slim. The auditor may be liable to third parties for their loss as a result of negligent audit done by the auditor. There are circumstances where the court may find the auditor liable to a third person who relied on the audit account if the following conditions are fulfilled. So for the number 1 is the loss or damage suffered by the plaintiff was foreseeable. So for the number 2, there was an existing relationship of proximity between the auditor and the plaintiff. So for the last one is it is reasonable to impose on the auditor a duty of care toward the plaintiff. So for this case, we use section 265, registration of firm of auditors. Section 1, a new firm of auditors shall notify the register that following particulars within 30 days from the date of commencement of business. Subsection A, the name of the firm. Subsection B, the firm number. Subsection C, the address of the principal place of business and the address of each other place of business, if any. Subsection D, the date of commencement of business. Subsection E, the full name, address, approval number, and other particular of all the partner, and such other particular as the register think appropriate. Subsection F, such other particular as the register think appropriate. So we also use section 265, subsection 2. The notification in subsection 1 shall be in the form as determined by the registrar. So for the subsection 3, the registrar shall cause a register of form of auditors to be kept and shall cause to be entered in the register in relation to a firm of auditors the particular referred to in subsection 1. So we also use section 266, subsection 2. An auditor shall in a report under this section, subsection A, whether the financial statement and if the company is a holding company for which consolidated financial statements are prepared, the consolidated financial statements are, in his opinion, properly drawn up. Subsection 1 Roman, so as to give a true and fair view of the matter required by Section 249 to be dealt with in the financial statement and if there are consolidated financial statement. Subsection 2 Roman in accordance with this act so as to give a true and fair view of the company affairs. Subsection 3 Roman in accordance with the applicable approved accounting standard or in the case where financial statements are required to be prepared for a lodge with the authorized refer to in Section 26D of the Financial Reporting Act at 1997. Such financial statements shall be made in accordance with the applicable approved accounting standards subject to any specification, guidelines, or regulation as may be issued by such authorities. So for this case, the application we choose case Caparo Industry against Dickman. So for the fact is a company called Fidelity, a manufacturer of electrical equipment, was the target of the takeover by Caparo Industry. Fidelity was not going well. In March 1984, Fidelity has issued a profit warning which had helped its share price. In May 1984, Fidelity's director made a preliminary announcement in its annual profit for the year up to March. This confirmed the position was bad. The share price fell again. At this point, Caparo had begun buying up shares in large number. In June 1984, the annual account, which were done with the help of the accounting man, were issued to the shareholders, which now include Caparo. Caparo reached a shareholding of 29.9% of the company, at which point it made a general offer for the remaining shares as the city court's rule on takeover required. But once it had control, Caparo found the Fidelity's accounts were in an even worse state than had been revealed by the director or the auditors. It sued Dickman for negligence in preparing the account and sought to recover its loss. This was the difference in value between the company as it had and what it would have had if the account had been accurate. So the issue is, could Dickman be liable to Caparo for the negligent preparation of relied upon company account, given there was no contractual relationship between the two parties? So for the help is, no duty of care was on. There was not sufficient proximity between Caparo and the auditors, since the auditors were not aware of the existence of Caparo nor the purpose of which the accounts were being used by them. A duty of care for negligent misstatement is more likely where the defendant is aware of the transaction the claimant and contemplating. Note that the defendant's advice will be communicated to the claimant, and note that it is very likely that the claimant will rely on the statement when making the relevant decision. It is unlikely to arise in relation to statements put in general circulation that could be relied on by anybody, this would lead to a fragment of liability. So for the case of number 1, the conclusion is no, Salem cannot sue Sarah because he not following condition fulfilled. So I will pass to the next presenter. Thank you.
Hello, my name is Valencia Lela Anatuan. So I will continue this slide for question 1, situation 2. In the meantime, Sarah had also provided her goods advice for the company to extend credit to Excel Holding after being satisfied that it was appropriate to do so based on their current financial status and position at that time. Unknown to her, an unprecedented worldwide pandemic took place shortly after the Excel Holding unable to settle their debts according to the contract entered. Tekun Niaga Berhad blames Sarah and now intends to sue her for the loss suffered, as in their opinion, Sarah had breached her duty by providing wrongful advice. The issue for this situation is whether Sarah had breached her duty by providing wrongful advice. The law for this situation too is Section 266, Power and Duties of Auditor. Section 4. An auditor of a company has a right of access at all reasonable time to the accounting and other records, including register of the company, and is entitled to require from any official of the company and any auditor of a related company such information and explanation as he desire for the purpose of audit. Next is Section 7. An auditor of a company or his agent authorized by him in writing is entitled to attend any general meeting of the company and to receive all notice of and other communication relating to any general meeting which a member is entitled to receive, and to be heard at any general meeting which he attends on any part of the business of the meeting which concurs the auditor in his capacity as auditor. The application for the case is Hadley Brain against Heller and Partner, 1964. The fact is Heller and Partner, a bank, assured Hadley Brain, an advertising agency, that a client firm, Easy Power Limited, could pay for their service and was creditworthy. Hadley Brain therefore took out €17,000 of advertising space on behalf of Easy Power, who subsequently default on the payment. Hadley Brain sued Heller and Partner on the ground that it had provided negligent advice which Hadley Brain had reasonably relied upon, leading to its financial determined. The bank successfully defended itself by pointing to a disclaimer in its advice that absolved it of responsibility. Although the case on the fact was settled, the court went on to discuss obiter the grounds by which a duty of care would arise when negligent advice was given, which result in economic loss. There are 3 requirements for this: reasonable reliance, assumption of responsibility, special relationship of trust and confidence between the parties. The issue for this application is, did Heller owe Hadley a duty of care? Does the duty of care apply to statements that cause pure economic loss? The decision is the court dismissed the case saying there was no duty of care based on the fact. A duty of care can arise with respect to careless statements that cause pure economic loss. Reliance by the plaintiff on the defendant, skill and judgment has the basis of liability. Conclusion is, Hadley brings serves as a warning to professional service firms that they can have a responsibility to more than just their direct client. While inadequate or negligent advice to a client may be actionable in contract, there could also be a class of third parties whose loss may also be recoverable in tort. The conclusion for this situation 2 is, yes, Sarah had breached her duty by providing wrongful advice. That's all for me, so I will pass this slide to the last presenter. Thank you.
Hi, I'm a last presenter, Nur Hanis Putih Bahari. I will explain to you about question 2, which is, Azlan is an auditor acted for Bosco Sindiran Berhad, had been terminated on 23 April 2023 by the company managing director on the ground that he is not competent and fails to execute his right duty. He, who had only received termination letter in the early morning, also found out that all his personal belongings were removed and vacated from his office in the company. With utter confusion and dissatisfaction, Azlan wanted to challenge his termination as he feels that it was done in malafide and did not in accordance with the right principles and procedure under the Companies Act 2016. Auditor is an independent person, professional authorized to inspect, review, examine, and verify the accuracy of business record to ensure true and fair account of past financial performance and current financial position. Under Section 266, Subsection 2, Subsection 3, it talk about auditor's main duties, which is to examine and form an opinion as to whether the financial statements have been drawn up in accordance with the financial reporting standard of Malaysia. Next, to examine and form an opinion as to whether the financial statement to give a true and fair view of the financial position of the company as of the financial year end and of its financial performance and cash flow for the year. Next, to obtain reasonable assurance that the financial statements are free from material misstatement. Next, to report that the accounting and other records and the register required by the Companies Act to be kept in accordance with the provision of the Act. Last, to immediately report in writing to the registrar if he or she has reason to believe that an offence involving fraud and dishonesty is being or has been committed against the company by officer or employees of the company. Next is right and privilege of an auditor, which is to access at all reasonable times all accounting records including all company registers and any other related information from company officers and auditors under Section 266, subsection 4. An auditor may be removed or terminated from the office before the expiry of his or her term. As an auditor can be removed from office by member at any time by passing an ordinary resolution at the AGM, in which a special notice of the resolution should be given at least 28 days before the scheduled members meeting under Section 276. Under Section 277, state that upon receiving the notice, the auditor may make a written representation within 7 days of receiving the notice and to have the right to be heard at the meeting. The auditor may request a copy of the representation to be circulated or read to every member at the meeting. Next, the auditor may be removed at the general meeting by a resolution passed by a majority of votes, which is more than 50% of members, and another person can be appointed as an auditor at the same time. Moreover, Section 297, subsection 2 prohibits the removal of an auditor by a private company by passing a written resolution. Next, the company is required to give a notice in writing to the registrar within 14 days after the removal, in which the registrar will appoint an auditor if the company did not appoint a new auditor under Section 278. And last, the auditor cannot be removed by directors. Name of the case is Pipara & Co. LLP against Tourism Corporation of Gujarat Limited. Issue of the case is statutory auditor appointed under Section 139 of the Act 2013 without giving any opportunity of hearing or without any show cause notice. Fact of the case: thereafter, Mr. Butt invited the attention of this court to Section 140 of the Act 2013. This is with respect to the removal, resignation of auditor and giving of special notice. It is argued by Mr. Butt that any auditor appointed under Section 139 can be removed from his office before the judgment date. Expiry of its term only by a special resolution of the company after obtaining the prior approval of the central government in that behalf in the prescribed manner. However, the emphasis is laid by Mr. Butt on the provision to subsection 1, Section 140, which provides that before taking any action under subsection 1, the auditor concerned shall be given a reasonable opportunity of being heard. It is submitted that the removal of the written applicant held of the case is, in case of violation of any of the above conditions by the appointed auditor, this office reserves the right to withdraw the audit allotted to the auditor at any point of time after following the due administration process. Thus, it is evident from the aforesaid that in case of violation of any of the aforesaid condition by an appointed auditor, the CNAG has the right to remove the auditor at any point of time after following the due administrative process. What is this administrative process is not clear. Even while following the due administrative process, the opportunity of hearing has to be given to the concerned auditor before his removal. The principles of natural justice are implicit in clause 11 referred to and highlighted. However, in the case on hand, it is not stand of the CNAG that action against the written applicant has been taken in terms of clause 11. conclusion of this question is yes, Aslan can challenge his termination according to section 277. Question 2 is at the same time, Bosco Sendirian Berhad had deferred the submission of annual return by lodging the document 2 months later than the company anniversary in January without knowing the consequences of such breach. It was found that this was the company's third consecutive breach of Section 68 of the Companies Act 2016 since 2021. If you are appointed as an interim auditor for the said company, what will be your advice on the content, requirements, and principle with regards of annual return? The issue for this question is whether Bosco Sendirian Berhad follow the contents, requirement, and principle regarding to annual return. An annual return is a basic information of a company. It is the duty of the company to lodge its annual return to the registrar not later than 30 days from the anniversary of its incorporation. The annual return of the company should contain the following, which is address of register office, nature of business, branch office address if any, address register member if it not kept as at the register office, address of financial report records if it not kept at the register office. Next, it's in the case of company which a share capital, the following summary should be include total amount of indebtedness, particular of directors, managers, secretaries, and auditors, list of its members, and other information as the registrar may require. The annual return prepared shall be signed by a director or secretary of the company. The power in determining the form and manner in which the annual return is to be lodged is laid down by the registrar. Next, the registrar also has the right to strike off the company if the company fails to lodge an annual return for 3, 4, or more consecutive years under Section 449. Next, the company and officer who committed the offence of failing to lodge the annual return shall be fined not exceeding 15,000 ringgit and further fine not exceeding 1,000 ringgit. Name of the case is Director of Megan Armani Sendirian Berhad and Electronics Team Sendirian Berhad competent for failing to lodge annual return to Registrar of Companies. Issue of the case is failure to lodge annual returns by director can result in a fine or imprisonment. Fact of the case is the Petaling Magistrate Court today convicted Hasniza binti Weza, the director of Mega Armani Sendirian Berhad and Electronics Team Sendirian Berhad on 2 charges for failing to lodge the company annual return to the Register of Company under Section 165, Section 4 of the Company Act 1965. The magistrate bin Shahrar sentenced Haniza binti Wazir to a fine of 700 ringgit or in the past 7 days imprisonment for each charges. Hasniza Wazir paid the fine. In mitigation, Hasniza Wazir appealed to the court to impose a minimum fine. She is the sole breadwinner of her family and currently she is unemployed. In addition, she mitigated that her mother is taken ill and she has to bear the medical expenses. Head of the case is SSM view the offence under Section 165, Section 4, Companies Act 1965 as severe non-compliance offence. The failure to lodge a company annual return timely to SSM will deprive the public from having accurate information and updates on the company's standing and well-being. As such, company and its officers are reminded to strictly observe and comply with the requirement of the Companies Act 1960. The conclusion of this question is yes, Bosco Sendirian Berhad follow the contents, requirement, and principle regarding to annual return.